Chair, and thank you also for the very detailed answers. I would like to have some more detailed answer on some of the answers you gave. For example, on the trafficking issue, from the information provided by the Ministry of the Interior. Yes, of course, we would like to have it in writing, the statistics. And I listened carefully. So when you listed how many cases you had also amongst ones said you had 179 foreigners. So I would be interesting, is there kind of a trend or a particular nationality, like people from Myanmar? I really don't know. And what follows from this for your policy to help them? And the same, then you have not answered one. No, and in general, let me say, I think it is good that you, State Secretary, are so actively involved to cooperate with neighboring countries to enlarge or deepen good cooperation in fighting crime and improving security. Now, discussing human rights is also to discuss issues which are not going well. Therefore, my question specifically relates to this kind of a trend and to a report in the media that in this region, also from Laos, Vietnam, Cambodia, and other ASEAN countries, there seems to be a trend that human rights activists and political activists are disappearing. And if you could reflect on this, or maybe after I listened to you, you said you have even a joint working committee between Vietnamese, in this cooperation you do together. Such cases, like, which is a report from 2020 in the ASEAN Post, which was called ASEAN's Missing Activists. Where are they? Do you consider such trends in this working group also? Of course, it is difficult because there might be state agents being involved in such activities, but I think it would be very relevant, actually, for your cross-border working together. Let's see, related to this, and this is also the last time I can speak now in this dialogue, yesterday I also put the question to you, how is the situation for the human rights NGOs and activists in Cambodia itself? And could you, or are you considering, for example, to reform or to look at this law on civil society organizations, if we could have an answer on that again. On the feedback on training in human rights, thank you also for this very detailed information. And I hope that that you focus on the Convention on Enforced Disappearance equally strong as on others in the future, like you said, public lectures on it, and you said you have included this in the curricula of the legal scholars, but also it would be good to have training on this. I think you described the structure you have in all provinces to do public training with civil servants, army, the public, and so on. And I think to have a specific focus on enforced disappearance would be very positive. Now, also when you described on how you run the prisons and the registers and so on, I could also hear that the prisoners, when they are foreign nationals, have access to consular communication with their consular. This, for example, is one recommendations we have in our general comment on enforced disappearance in the context of migration. So I just advertise this to also improve the work and the work you are already doing on that. I had no answer that you are interested to reach out to the other ASEAN members to ask for ratifications. Maybe at your final sum up you could make an attempt. And we know that also from when we had the opening of our committee, we learned that in the UPR process, also neighboring countries like Thailand and Indonesia are considering to ratify. So perhaps it's a good time to encourage them to do so. Yes, now on the trafficking in persons. So that's really, as you said, it's a relevant issue in Cambodia, and you did a lot of work on that. But in your answers, you did not specify in all this what you do. What are you thinking, what can you do to prevent that victims of human trafficking are in addition not also becoming victims of enforced disappearance? And just to underline this, because they are very vulnerable people, and they are, in addition, when they come, for example, from a different country, so they are foreigners. Those who benefit in exploiting those victims are very well organized. So we have to have a special lens that they not become additional victims for enforced disappearance. Maybe you can come back on that. I think on the other questions, you gave very detailed answers. Okay. Maybe then Suela.
Ms. Janina, you have the floor.
Thank you, Chair, and many thanks to the distinguished members of the delegation of Cambodia for the replies that they have given to our questions. I think that there are some important points that, as we have time, we can dedicate more efforts to clarify everything, so we are clear enough about your system, be it legal or how it functions in practice. And I want to raise on the understanding that if we have time, the questions on children will come back from your side. I would like also to add another general question on that, on another special, I don't know if it's special, but I would like to see a little bit what is your approach on the issue of women and the fact that if they are victims of enforced disappearance, there is a broad Article 24 in our convention which addresses the general concept of the victim. The victim is not what we have seen like the traditional one, the one who suffers directly from the crime, you know, but it's a broader one. And in this respect, women are the most touched by this phenomena, especially because they remain like the only breadwinner after the majority of victims are men, and they have also the conditions to raise children and to keep up with family, and especially in different situations they are also struggling with legal obstacles like inheriting or other difficulties. So I would like to know a little bit in general from your perspective, what kind of approach Cambodia have towards women and their position in general in society, but especially when they are victim of crimes of abuse of human rights, and specifically if it happens to be enforced disappearance. And then I come back to more general and more concrete, from general remarks to more concrete one. Article 16 of the Convention, which deals with non-refoulement, it's a key article, because in cases when we don't have enforced disappearances in the country, what we look is if this principle of non-refoulement is really upheld in practice. That means that if there is any claim that someone may be subjected of enforced disappearance, authorities should take this claim very seriously and analyze a lot of elements. The first element is the individual assessment of the applicants or someone who is really being assumed to being a subject of enforced disappearance. And you mentioned that there are systems in the country to have the appeal if someone is not satisfied with the decision of administrative organs, they can go to the court and then to have the suspension of all the mechanism. And the second element is an assessment on the general situation on the respect of human rights on the country on which this individual is being returned or surrendered or extradited. And here it comes my question. Do you have any system of evaluating that? Usually there is also a kind of instrument that is used and it's called diplomatic assurances. Do you accept this kind of diplomatic assurances, and how you follow, to keep it more simple, a country on whom you are delivering or sending back or extraditing a person is giving you assurances that his human rights will be respected? How do you follow? What kind of procedure do you have to assess that? And it comes also with extradition, because I heard with great interest your information that you are going to take place in another activity now, distinguished member of the delegation, and it comes to a kind of draft that you are discussing on extradition. And it would be very welcomed from our side as well to see how this discussion would fit on the future discussion that you would have in that regard, that extradition can be mentioned or included as an extraditable, enforced disappearance as an extraditable crime under these new instruments that you are discussing. And this also, we need to note, it's an obligation for state parties, but still, to go beyond it, it will take really a good example of sharing good practices also with other countries with whom you are cooperating in the region and beyond. One element that I wanted as well to have more information is regarding the situation of the detainees and, of course, maintenance of registers. We understand that there are a few of them. We expect them to fulfill all the conditions that are put into the convention. But still, I wanted to ask a little bit on the fact of the visits on the detention places. If the National Committee Against Torture and Other Cruel, Inhuman and Degrading Treatment or Punishment is able to conduct visits to prisons, of course without notice, because this is the reason of let's say, the function of this kind of institution. And also, not only detention places, but in pretrial centers, in social centers, in transit centers, and also how the rights of the detainees in practice are maintained in terms of their ability or their access to the lawyer. You say that they have access to the lawyer. My question would be concrete in the time that they can access the lawyer. Is it immediately from the very outset of the deprivation of liberty, or there is a time limit on which the lawyer can meet his client and speak about his situation and offer to him the proper legal protection? And another question is, what is the situation on offering the legal assistance also to those that are not able to have a legal defender by themselves? Is the state offering them? What is the situation in that regard? And I think with that question, I would conclude. And also, as Barbara said, it seems that it will be our last possibility to address you, and I would like to thank you for the cooperation with this committee, and also to have the expectation, which I feel that will be addressed, that our concluding observation at the end of this dialogue will be taken with goodwill, to analyze them and to address them, because from this side, we have had the goodwill of trying to explain together with you what the obligations are, and as you have been honest with us to say where the lagunas or let's say, the lack of specific legislation or measures are taken, we would like to continue in this spirit of cooperation in order to assist you, if we can, and to work together in making possible the full implementation of this important convention in your country. Thank you.
Merci.
Thank you. Thank you very much, Ms. Janina, for those questions. I have 3 further requests for the floor. I'll begin by giving the floor to Mr. Horacio Ravena.
Gracias, Presidente.
Thank you, Chair, and a good morning to the members of the delegation. Thank you for all of your answers thus far. I echo the questions asked specifically by my colleague, Ms. Janina, on the topic of non-refoulement and all the issues surrounding that. I think that she has flagged a number of concerns that I also harbored. I would like to ask you whether you could inform us, please, about the composition of the administrative committee which decides on requests for refugee status, whether it rejects or accepts them. You referred to this body, but I'd like to know what its composition is. You also referred to the fact that they also review non-refoulement issues. You referred to this administrative body, administrative committee. So I'd like to ask whether this administrative body, or rather to ask what the composition of this administrative body is and what its ranking is within the government and what its power is, its autonomous power for decision-making. Finally, in referring to your National Anti-Trafficking Commission, you made a comment which we view very favourably. And that is that you have been invited, or rather civil society organisations have been invited to collaborate with your National Anti-Trafficking Committee and to cooperate with the government in the quest for a solution to this whole issue of trafficking. And as I say, that's always a very positive step. I would request information from you as to the way in which you select civil society organisations with which the committee will cooperate, and whether there is any rotation in cooperation with civil society organisations, whether there's a rotation in which civil society organisations form part of or partner directly with your National Anti-Trafficking Committee. Thank you very much.
Merci beaucoup.
Thank you very much, Mr. Ravena. I give the floor to Ms. Carmen Rosa Villa-Quintana.
Buenos días.
Good morning to the members of the delegation, and thank you very much for the replies that you have shared with us. I want to revisit a point which, in reading your replies to the list of issues, was one that struck me and about which I have some doubts. It's related to paragraph 31, when you talk about your immigration law. And you state that an expulsion order has to be carried out immediately from the date of signature from the Ministry of the Interior. This is paragraph 38, subparagraph B. You then also state in that same subparagraph that the concerned person shall have rights to file complaint to the court within a period of 2 months. So that leads me to my question. If the decision for expulsion must be carried out immediately, how can they file a complaint within the 2-month period following that expulsion? Can it be done from outside the country? How do you guarantee that people can exercise this right as concerned persons to file a complaint to the court within a period of 2 months contesting an immediate expulsion order? I welcome your explanations on the extradition procedures in Cambodia, but this gives rise to a further concern, and I'd welcome some clarification. I'd like to ask whether in your country there is an example of an individual who has been sought as the subject of an enforced disappearance in another country. Now, you do not have enforced disappearance as an autonomous crime in your legislation. And so this, and to other problems, gives rise to the spectre of double indemnity. We also have, of course, the fact that there's no recognition of the continuous nature of the crime and your refoulement procedure. So I'd like to ask that, given the principle of non-statute of limitations and double indemnity, what do you do to handle cases involving enforced disappearance, either a third-party national in Cambodia or an enforced disappearance that occurs abroad? On reparations, may I ask whether you have holistic reparations and remedy mechanisms in place, and ones that function automatically? Now, you were very clear in your responses, in your answers, that persons may pursue civil proceedings in those instances where they can pursue reparation and damage for mistreatment or abuse, etc., abuse of their legal rights. I'd like to ask how that is functionally done. Are there mechanisms? Is there a list of victims? Or do you intend to put together a list of potential victims of serious violations of human rights and inform them automatically of their access to a holistic reparation mechanism and how that will function for them? In light of the presentation we had on human trafficking and Cambodia's efforts in this field from the member of the delegation, it was a very detailed presentation of your anti-trafficking efforts, and I would like to underscore a point made by my colleague Ms. Barbara Lochbihler. A reference was made to 179 foreign persons who've been identified as part of your anti-trafficking activities. And according to a point made by a member of the delegation, measures are being taken to protect these foreign individuals. So I'd like to ask specifically, what are these protection measures? Of what do they consist? In order, in particular, to guarantee that foreign persons would not end up being the victim of disappearance. So what do these protection measures specifically consist of? I'd be very grateful if you could answer that particular question. I'd also like to touch on the issue of registers of detained persons. You stated that there were 10 different registers which are used depending on the criminal process or the state or current status of the individual. Those who are first being received in a place of detention, those already in it, those who are post-trial, etc. I would like to ask whether there is any interoperability between those different registers. Can an individual, for example, go to the Ministry of Justice and have access to a whole list of all the detainees in the country, each and every one of them? Because I'd like to know where this individual is, where they're being held, in what facility, what the charges leveled against them are, where the process currently stands in terms of the prosecution, etc. In other words, how have you managed to implement the provisions of Article 17 of our convention? I believe you also made a point that a complainant has a right to have access to all of this information contained in the registers. So I'd like to know what the scope of access to this information is in addition to complainants. Can persons with legitimate interest have access to this information? And in asking that question, I'd like to ask if you have a definition of who persons with legitimate interest are who might have the right to ask information about the state or circumstances of a detained person. Two final concerns or two final points of clarification. You talked about a broad capacity building program or training program in human rights. And you talked about a request from the OHCHR, or a request to the OHCHR about capacity building on integration in human rights in the training program for judges and legal officials. But I think a reference was made to the fact that this cooperation program was suspended. Was it suspended because of a point of difficulty, a particular point of difficulty? And I'd also like to ask how that training is delivered when it does go ahead. And is it continuous training or is it a single 2-3 day workshop? And then how do you measure and assess the integration of this training, the impact of this training, the extent to which it is used and referred to by judges, legal officials, the beneficiaries of this broad-ranging human rights training that you have provided? And I'd like to come back to a question that I asked yesterday that wasn't responded to, and that was about the transparency of legal decisions when those involved in the legal decisions or those cited are judges being prosecuted or cited for corruption. You talked about confidential handling or in-camera handling of cases. But one important element of justice is transparency. How can the public at large know if they have reliable judges? How can they know that given judges have been charged with corruption, etc.? Is this knowledge made public? Are these judges publicly dismissed? Are they removed from office, etc.? And are they particularly, and I would like to know in particular what happens when judges are accused of corruption and they're involved in cases of serious human rights violations. Given that this will be likely to be the last time that I get the opportunity to take the floor, I'd like to thank you for your openness, your frankness, and for your willingness to engage fully in this constructive dialogue with the committee. Thank you. Thank you very much, Ms. Vija Quintana. I give the floor to Mr. Mata Diop. Thank you, Chair. I hesitated about taking the floor, but I do want to talk about the Khmer Rouge genocide issue. You touched upon it briefly yesterday. It is a major and bloody milestone in the history of Cambodia, which had a severe impact on Cambodian society. The issue seems to have been closed as a result of a ruling in the United Nations jurisdiction, the ECCC, which leveled the charges, prosecuted those accused, and sentenced them. That said, there are millions of victims of enforced disappearance as a result of this genocide. This whole sad history in Cambodian chapter in Cambodia history. And according to our convention, particularly Article 24, the relatives of the victims have the right to memory. They have a right to know what happened to their loved ones, to their relatives. And they also have the right to reparation. So my concern, or my question rather, is to ask what the Kingdom of Cambodia is doing in this understanding that the Cambodian state is a continuation of the state. What is the Cambodian state doing to try to identify the remains of the disappeared persons, or the whereabouts of the disappeared persons? Several decades have elapsed now, and we've had no news of this disappeared persons. What steps is the state party taking to identify and find their remains? And what steps is being taken by the state party to give hope to surviving victims? And may I also take this opportunity to thank the delegation for your willingness to cooperate with the committee, for your frank exchanges. Thank you very much for that. It's much appreciated.
Merci beaucoup.
Thank you. Finally, I will give the floor to Mr. Fidelis Kanyongolo. You have the floor.
Thank you very much. Appreciation to the delegation. I have just two specific questions, and I think we're running out of time. The first one relates to data, and I want to appreciate the Minister of the Interior's presentation on a very detailed, disaggregated set of data on human trafficking. The question is whether this level of disaggregation of data is also available with respect to the other aspects of the criminal code, which arguably stand in place of the convention, because I think we will not return to the autonomous creation of, I think that has been adequately discussed. But the issue of human trafficking, lots of data broken down in terms of gender, age, etc. of victims. Argument is enforced disappearances are covered in different laws. Is there a level, the same level of disaggregation of data, detailed data on victims under these different laws? The second relates to training. And as my colleague, I think Carmen, and I think Barbara pointed out, it is appreciated that there is a broad range of human rights training taking place. But I think I just wanted you to underscore or clarify this. Under the current training programs that you outlined, how much of that focuses on enforced disappearances? I think that if we can get that, because that is the specific legal obligation under the convention. Thank you, Chair.
Merci beaucoup.
Thank you very much, colleagues. Perhaps before giving the floor back to the delegation, given that we have a little bit of time in hand as member of the committees, I'll ask 2 follow-up questions of my own. The first, to build on the questions asked by my colleague, Mr. Matar Diop. As you're aware, Article 35 of the Convention prevents the committee from examining individual cases of enforced disappearance that began before the entry into force of the convention itself. And nonetheless, the committee is always interested, as part of its constructive dialogues with state parties, in hearing from given state parties about the measures that they have taken to duly take into account historical enforced disappearances that took place in the past as a way of optimally implementing the convention and its provisions. Well, that's why we're very interested in what may be called transitional justice measures, which are covered in particular by Article 24 of the Convention, which is on the right to truth and right to reparation, as cited by Mr. Diop. And that is why our committee in this particular instance would be interested in learning more about how Cambodia implements the right to truth for victims of the genocide under the Khmer Rouge and those who disappeared, and the relatives of those who disappeared. Particularly when it comes to reparations, and this circles back to a point that we made yesterday, and that is the trials carried out by the ECCC. Several victims were represented at the trials before the UNECCC, and so I'd like to know what reparations have been implemented as a result of the findings by the Extraordinary Chamber, the UNECCC. Turning now to another issue, that of judicial cooperation. We've talked a great deal about that. You've gone into a great wealth of detail about judicial cooperation, which we welcome. Article 15 of the Convention imposes an obligation on states party to the Convention to cooperate with each other to provide mutual assistance on behalf of the victims of enforced disappearance. Particularly to mutually assist one another in searching for and locating disappeared persons. And off the back of that, I'd like to ask a question to the delegation of the Kingdom of Cambodia, which links to a question asked by my colleague Ms. Janina about illegal international adoptions that you've not yet had an opportunity to answer. Because this is a key area for international cooperation between state parties under Article 15. It's a prime model of where that cooperation should be and can be brought to bear. Because, of course, if it's international adoption, at least 2 states will be involved. Recently, several different organizations have flagged and expressed the hopes about international cooperation between Italy and Cambodia on this whole issue of illegal international adoptions. But there have been concerns flagged that this cooperation might not bear fruit or might not be properly pursued because of some reservations about a recognition of international legal adoptions, safeguards surrounding them, etc. We'd like to know more about Cambodia's stance on that, particularly given the fact that Cambodia is a signatory to the Hague Protocol on adoption, and given the fact that allegations of illegal international adoptions continue to persist, and they continue to occur today, according to the reports that we hear, but also occurred in the past, including, for example, between Cambodia and Italy, the 2 countries that I cited earlier. So what measures will be taken by the 2 countries to shed light on historic illegal international adoptions that occurred in the past, in other words, prior to the adoption of the Hague Convention and to this convention, our own convention by Cambodia? So the floor is yours. You have time in hand to respond to the questions, and if some additional time is remaining, we will engage in a further interactive exchange if judged useful. You have the floor, Head of Delegation.